Enough. One word. That's all it took, according to the official court transcript. One word from a judge who had finally reached his limit. The defense attorney froze mid-sentence. The gallery went silent. And the cameras captured what legal analysts are calling the most significant courtroom moment of the year. This is my courtroom, not a political rally, not a media circus. My courtroom. According to newly surfaced court records, the defense team had been pushing boundaries for weeks, testing limits, playing to the cameras instead of the jury. But on this day, this specific moment documented on page 247 of the transcript, the judge did something nobody expected. He took control, and he didn't apologize for it. So what pushed this judge over the edge? One moment, one decision, one line the defense should never have crossed. According to court filings dated just last week, the defense attorney stood up during a critical phase of testimony and launched into what witnesses described as a political speech, complete with references to outside investigations, media narratives, and what the transcript calls inflammatory characterizations that had nothing to do with the evidence at hand. But here's the thing, this wasn't random. This was weeks of boundary pushing finally catching up. The documents show a pattern going back to the first pretrial hearing, where the judge issued his first warning about courtroom conduct. The defense ignored it. The second warning came during jury selection. Ignored again. The third warning, documented in a sealed sidebar conversation now made public, included a specific threat. One more outburst, and I will take action. And I'm going to show you exactly how it all fell apart, filing by filing, warning by warning. The moment everyone's talking about? It's coming. But first, you need to see what the defense did to earn it. Because according to these records, this wasn't judicial overreach. This was a judge doing exactly what judges are supposed to do. Here's what actually happened, the moment everyone clicked to see. Tuesday morning, 9:47 a.m., courtroom 4B. The air was already tense, according to multiple witnesses quoted in local court coverage. The prosecution had just finished presenting a key piece of forensic evidence, methodical, professional, by the book. Then the defense attorney stood up. According to the official transcript, he didn't address the evidence. He didn't challenge the methodology. Instead, he turned partially toward the gallery where cameras were positioned and began what the court record describes as an extended narrative statement. Your Honor, what we're witnessing here is part of a larger pattern. The judge's voice cut through immediately. Counselor, do you have an objection to the evidence presented? I'm laying foundation, Your Honor. You're laying something. It's not foundation. The gallery shifted uncomfortably. Court reporters noted audible reactions. The defense attorney continued anyway. That's when it happened. According to the transcript, page 247, lines 12 through 34, the defense attorney referenced ongoing investigations in other jurisdictions, suggested the prosecution was politically motivated, and used the phrase witch hunt 3 times in 90 seconds. The judge's gavel came down hard. Once, twice, 3 times. Counselor, approach, now. What happened at that sidebar is now part of the public record. The judge's words captured by the court reporter. I have warned you repeatedly. This is a court of law. We deal in evidence, testimony, and legal argument. Not talking points, not sound bites, not whatever you're preparing for your press conference afterward. The defense attorney reportedly responded, Your Honor, I'm simply advocating for my client. The judge's response, documented verbatim, no, you're performing, and I'm done watching the show. Return to your table, address the evidence, or sit down. Those are your only options. The courtroom fell completely silent. According to witnesses, the defense attorney's face went pale. He stood frozen for approximately 4 seconds, an eternity in courtroom time. But here's what nobody saw coming, what the extended transcript reveals. The defense attorney didn't sit down. He doubled down. Your Honor, with respect, I believe the record should reflect... The gavel again, harder this time. The record will reflect that you've been warned 4 times about conduct. The record will reflect that I've shown extraordinary patience. And the record will now reflect this. He leaned forward, every eye in the courtroom locked on him. This is my courtroom, not a political rally, not a campaign stop, not a television studio. You will conduct yourself as an officer of the court, or you will be held in contempt. There is no third option. There is no appeal from this warning. Am I absolutely clear? According to the transcript, the defense attorney responded with 2 words. Yes, Your Honor. He sat down. The prosecution resumed. Official records show the remainder of that day's proceedings continued without further incident. No more speeches, no more references to outside investigations, no more playing to cameras. The judge had done in 90 seconds what weeks of warnings couldn't accomplish. He reminded everyone who controls a courtroom. If you're watching this thinking, finally, a judge who actually maintains order, hit subscribe, because this story has layers the headlines aren't covering. And I've got the court filings to prove every single claim I'm making here. But not everyone sees it that way. And honestly, their argument is stronger than you might think. The defense team and their supporters are calling this judicial overreach. Before you dismiss them, hear this out, because some of what they're saying actually checks out. One criminal defense attorney with 23 years of experience, not connected to this case, but commenting on the transcript, put it this way. Zealous advocacy is not just permitted, it's required. Defense attorneys have an ethical obligation to fight for their clients using every legal tool available. When a judge shuts down that advocacy, even if it feels excessive, we should all be concerned. Today, it's this attorney. Tomorrow, it could be any of us. That's not nothing. That's a legitimate point, backed by decades of legal precedent. Social media is split down the middle. Thousands of comments are saying the judge was biased, that he's been harder on the defense than the prosecution throughout the trial, that this outburst reveals his true feelings about the case. And here's where it gets uncomfortable for those celebrating the judge. According to court watchers who've tracked the full trial, the prosecution has made similar boundary-pushing statements. References to the defendant's character, implications about other potential crimes, and received gentler corrections. One legal blogger documented 7 instances where prosecution overreach received a quiet sidebar instead of a public rebuke. There's a pattern here, one defense side legal analyst noted. When you tally the public admonishments versus private corrections, there's a noticeable disparity. That's the kind of thing appeals courts look at very carefully. Even neutral observers, journalists covering the trial daily, are admitting the judge may have been legally correct, but the optics are complicated. Publicly dressing down defense counsel in front of cameras creates its own narrative. Some will see strength, others will see bias. The truth probably requires watching the full trial, not just this clip. Constitutional law scholars are raising a more fundamental question. One professor at a major law school, someone who's argued before appellate courts, offered this. Judges have enormous discretion in controlling their courtrooms. That's by design. But that discretion can become a weapon if applied unevenly. The question isn't whether this judge can do what he did. Clearly, he can. The question is whether he should, and whether he'd do the same to the other side. So let me be clear about something. I'm not here to tell you who's right. Is this judge actually restoring order and protecting the integrity of the proceedings? Maybe the evidence supports that reading. Or did he cross a line that chills legitimate defense advocacy? That's also possible. And there's evidence for that interpretation too. The truth? It's probably somewhere in between. And that's what makes this story so important to examine carefully. What I can tell you is what the documents actually show. And the documents show a pattern of escalating conflict that was building toward exactly this moment. But this didn't come out of nowhere. 6 weeks before this explosion, the warning signs were everywhere, documented in pretrial motions and hearing transcripts. The very first pretrial conference, the judge established what he called ground rules. According to the filing, he specifically prohibited speeches, political commentary, or references to matters not in evidence. The defense filed an objection. Denied. A former federal magistrate who reviewed the early transcripts said something that should have been a wake-up call. This judge was clearly drawing bright lines from day one. Any experienced attorney would recognize that as a signal. Push at your own risk. Did the defense listen? The record suggests they didn't. During jury selection, the defense attorney made what the transcript calls an extended statement regarding the political climate. The judge stopped him. Warning number 2. During opening statements, another boundary push, another warning, this time sharper. Records show that every week the defense tested a little harder. Every time they got a warning instead of consequences. Until that Tuesday morning, when they didn't. The pattern in the filings is unmistakable. A judge trying to maintain control, a defense team testing limits, and an inevitable collision that everyone should have seen coming. One courtroom observer who's covered trials for 15 years put it simply, this judge gave them more rope than most would. They chose to hang themselves with it. The stage was set. The defense just didn't realize they'd run out of warnings. Drop a like if you see where this was heading. The pattern in these documents is crystal clear, and we haven't even gotten to what happened after the judge's rebuke. That's where this story gets really interesting. And then it happened. Tuesday, 9:52 a.m., courtroom 4B, 5 minutes after the first warning of the day. According to the transcript, the gallery was still processing the judge's previous comments. The defense attorney had just returned to his seat. The prosecution was preparing to call their next witness. Then the lead defense counsel stood up again. Your Honor, before we proceed, I need to make a record. The judge's response was immediate. You may make appropriate objections when appropriate. This is appropriate, Your Honor. I'm noting for the record that this court has consistently the gavel. Counselor, I just explained this. Did you not hear me? I heard you, Your Honor, but my client has rights, and one of them is your client's rights are being protected by these proceedings. Your conduct is not protecting anyone. It's creating reversible error. Now sit down. The official transcript notes a 4-second pause. The defense attorney sat. But according to witnesses quoted in post-hearing coverage, his face told a different story. Defiance, frustration, the look of someone who believed he was right and was being silenced anyway. The judge addressed the courtroom. Let me be clear for everyone present, including the media. This trial will be conducted according to rules of evidence and procedure, period. Anyone, and I mean anyone, who attempts to turn this proceeding into something else will face consequences. There will be no more warnings, only actions. 17 seconds, that's all it took. 17 seconds to establish control so complete that according to the remainder of the day's transcript, not a single objection was raised for the next 3 hours. But here's what everyone missed while they were focused on the drama. According to sidebar notes released later, the judge also told the prosecution, this applies to both sides. Don't test me. Equal warning, both directions. That detail didn't make the clips. Don't go anywhere. What I'm about to reveal changes how you should view this entire situation. Drop a comment. After hearing both sides, whose argument is stronger? The judge maintaining order or the defense claiming overreach? Legal scholars who specialize in judicial conduct and trial procedure are calling this a case study in courtroom management. One former federal district judge, someone who presided over high-profile cases for 18 years, broke it down. What you're seeing is a judge who decided that preserving the trial's integrity mattered more than avoiding controversy. That takes courage. Most judges would issue endless warnings to avoid exactly this kind of media attention. He drew a line and held it. Let me translate that into plain English. Judges usually take the path of least resistance. This one didn't. A criminal defense attorney with 2 decades of federal court experience added something crucial. I've been on the receiving end of judicial frustration. It's never comfortable. But watching this transcript, I can't say the defense didn't earn it. There's advocating zealously, and there's ignoring direct orders. Those are different things. Here's what former prosecutors are discussing behind closed doors. This sets a precedent, not legally, but culturally. Other judges are watching. Defense attorneys are watching. The message is clear. Political theater has limits in federal courtrooms. Some will cheer that. Others will worry about it. But it's not just one side. Even civil liberties advocates are weighing in. We should always be vigilant about judicial power, but we also need courtrooms to function. A trial where attorneys can ignore the judge isn't protecting anyone's rights. It's creating chaos. The balance here is genuinely difficult. Constitutional law professor from a top-tier law school offered the most nuanced take. The judge was within his authority. The defense was within their rights to push back. Both things can be true. What matters now is what the appeals court says, if there is an appeal. That's where the real precedent gets set. The legal consensus, and this is rare to see, seems to be this judge walked a tightrope, and whether he made it across depends on who you ask. Smash that like button if this legal breakdown is helping you understand what's really at stake here. It's more than just courtroom drama. It's about how our entire justice system functions. Like if you want more analysis like this. So what does this actually mean for you specifically? Right now, legal teams across the country are watching this case. According to legal news outlets, at least a dozen high-profile trials currently underway have defense teams employing similar tactics, playing the cameras, referencing outside investigations, pushing political narratives. But here's the thing. If you ever end up in court for anything, this affects you directly. Here's how. The balance between aggressive advocacy and courtroom order determines whether you get a fair trial or a circus. If judges crack down too hard, your attorney can't fight for you. If they're too lenient, the other side turns the courtroom into a media event at your expense. Trials that devolve into political theater take longer, much longer. According to judicial efficiency studies, proceedings with excessive attorney misconduct last 40% longer on average. What does that mean for your wallet? Longer trials mean higher costs for everyone, including taxpayers funding public defenders and court operations. If you're ever involved in civil litigation, every extra day in court is money out of your pocket. If you're a business owner, a landlord, or anyone who might end up in civil court, you should care deeply about judicial efficiency. Here's the bigger picture that should concern all of us, regardless of where you stand politically. If this judge's approach becomes standard, it means cleaner trials, but also more judicial power over attorney conduct. Every time you hire a lawyer, the judge's temperament matters as much as your attorney's skill. Let me give you a real example. Imagine you're wrongly accused of something. Your attorney wants to explain the political context of why you're being targeted. The judge says, no, that's political speech. Now your defense is limited. That's not fear-mongering. That's the legal reality of expanded judicial discretion. Now, I'm not giving legal advice, but here's what informed people are considering. If you're ever called for jury duty in a high-profile case, understand that what happens inside the courtroom is often different from what makes the news. If you're ever a party in a trial, ask your attorney directly. What's this judge's reputation for courtroom control? Follow judicial elections in your jurisdiction, because who sits on the bench determines how these balances get struck. And here's what nobody in mainstream coverage wants to say out loud. We want judges to control their courtrooms until they control something we care about. Then suddenly it's overreach. Think about it. If this judge had silenced a prosecutor making political speeches, the same people angry now would be cheering, and vice versa. That inconsistency, that's the real problem with how we talk about judicial authority. If you care about fairness, you can't just care when it benefits your side. And then the defense team responded outside the courtroom and made everything more complicated. According to video from the courthouse steps, taken within an hour of the morning session, the lead defense attorney held an impromptu press conference. Instead of moving on, he chose to escalate. What you witnessed today was not judicial authority, it was judicial activism. Our client is being denied his fundamental right to a vigorous defense. The public reaction was immediate and polarized. The clip went viral, 3 million views in the first 12 hours. Comment sections became battlegrounds. But here's where it gets concerning. According to court filings submitted the following morning, the prosecution requested sanctions against the defense for attempting to try the case in the media. The motion specifically cited the press conference. The defense filed a counter motion accusing the judge of bias and requesting his recusal from the case. The judge's response, issued in writing, "Motion denied. We will proceed." One legal commentator noted, "This is now a war. It's not about the evidence anymore. It's about control of the narrative, and wars have casualties." The prosecution's latest filings, submitted just days ago. Defense counsel's continued public statements undermine these proceedings and demonstrate the precise pattern of conduct the court has already admonished. The defense response? "We will not be silenced. Our client deserves a full and fair defense, not a muzzled one." This isn't ending, it's escalating, and the next motion hearing is scheduled for next week. But here's what's bothering me, and I've gone through all the public filings. Why did the defense push this hard on this day? The timing seems deliberate. According to the court calendar, a major procedural ruling was expected that afternoon. Was this strategy? Were they trying to provoke exactly this response to build an appeal argument? Sources close to the case are suggesting the defense may be building a record for post-conviction relief, arguing that judicial bias prevented a fair trial. The judge has scheduled a closed-door hearing with both legal teams for next Tuesday. No cameras, no press. The topic, according to the docket, case management and counsel conduct. Whatever happens in that room stays sealed. Meanwhile, the defense team has retained a separate attorney, someone who specializes in judicial misconduct claims, according to Legal News reporting. That's not a move you make if you're planning to calm things down. The judge has reportedly ordered all staff to direct media inquiries to the court's public information office only. Something is developing beneath the surface. And based on the timing of these filings, both sides are preparing for a much longer fight than the trial itself. The question is, who blinks first? Subscribe now, because this story is far from over. The moment those sealed hearing documents become available, I'll break them down. Turn on notifications. You'll want to see what happens next week. Here's where things stand as of today. The trial is ongoing. Both sides are still presenting evidence. But the atmosphere in the courtroom, according to reporters who've attended every session, has fundamentally changed. The defense is noticeably more measured. Objections are brief and technical. The political rhetoric has disappeared, at least during court hours. The prosecution has also pulled back on certain characterizations. Whatever the judge said to both sides privately, it seems to have landed. But here's what's not in any official report yet. According to courthouse sources, and I want to be clear, this is not confirmed in documents, both legal teams have been seen meeting separately with the court's administrative staff. The topic of those meetings is unknown. Key dates coming up. Next Tuesday, closed-door hearing on counsel conduct. Following week, expected completion of prosecution's case. 2 weeks out, defense case begins in earnest. Potentially 30 days from now, verdict if no more delays. The jury has been instructed to avoid all media coverage. Whether they're succeeding is anyone's guess. The clock is ticking toward a verdict. But the real story might be what happens after. But here's what keeps coming back to me after reviewing all of this. This judge drew a line that most wouldn't. On the surface, it looks like a clear case of judicial authority properly exercised. But stories like this, they rarely end where we think they will. If the appeals court sees bias, everything changes. If they see appropriate control, this judge becomes a model. If the defense's media strategy works, public opinion shifts. If it backfires, their client suffers. The truth? It depends on which documents you read and how you read them. Is this judge a hero restoring courtroom integrity or an obstacle to vigorous defense? The answer might be both. It might be neither. The truth is still unfolding. The verdict hasn't been reached on the case or on the judge's conduct. What I can promise you is this. I'll keep tracking the filings. I'll keep following what happens in that closed hearing next week. And I'll keep breaking down what it all means without telling you what to think. Subscribe if you want the full picture, not just the viral clips. Notifications on, because this case is teaching us something important about power, courts, and who really controls the narrative. I'll see you in the next